Enough said. I believe it's time, actually. I have the pleasure to welcome three prominent speakers today. Dr. Najjar, you're first. I will leave you the floor. Thank you.
Thank you, Mr. Kouatli, for this presentation. Thank you all for being here today. Thank you, organizers, for inviting me to speak on a very important issue that, to my point of view, has not been sufficiently and enoughly stressed on in this seminar. That is the dispute resolution clause, key factor for the efficiency of oil and gas contracts. Well, the subject I'm dealing with today, allow me to refocus it in a way. Oil and gas contracts are qualified as investment contracts. This qualification is, of course, a major issue because legal consequences can be derived therefrom, and most particularly the relevant source of law that could eventually rule agreements related to investment contracts. Oil and gas contracts, as you know better than I do, of course, are of national interests and involve most oftenly Lebanese and state organs and public entities, as the oil and gas are generally within the public domain. Let's imagine this scenario. Parties enter into an exploration and production sharing agreement whereby the government grants the investor the exclusive right to explore, to drill, and produce petroleum in a defined area. Generally, well, of course, in Lebanon, it should be offshore area within some zone in the sea. And this contract should have probably been executed for a lapse of time, which generally varies between 20, 30 years. And of course, there are some profit sharing between the investor and the Lebanese state. These are, I mean, this is a scheme, of course. It's not necessarily the only type of agreement, but let's say this is the type of agreement. Well, there is a key factor. There's a key issue here. Whenever there's a dispute, well, I'm sure that whenever there's a dispute, the investor would be extremely reluctant to the idea to just resort to national courts and Lebanese national courts, of course. And of course, the investors too would be, I mean, the Lebanese state too would be very reluctant to the idea to just withdraw from its sovereignty and public powers and resort to the investors' state courts also. So, what would be the solution in that case? Generally, there is one solution that is most commonly resorted to, which is arbitration. Arbitration is a private way, it's a conventional way to settle disputes relating to investment disputes, but also to commercial trade disputes internationally and probably, of course, nationally. And the issue of resolving disputes is a key factor because, well, the whole efficiency of the contract can rely on this dispute resolution clause. And I won't exaggerate by saying that the investor or even Lebanese state, but generally the investor would consider this clause, the dispute resolution clause, as a condition, a prerequisite, a precondition to the signing of the contract, since the whole fate of the contract could rely on this dispute resolution clause. So this is to stress out on how important this clause is, and I'm sorry to see that in this conference it hasn't been sufficiently pointed out that the dispute resolution clause and dispute resolution as a whole has not been, appropriately dealt with. However, let's say there is this dispute resolution thing, And here there are two options generally available for investment contracts, and of course oil and gas contracts that are investment contracts, as I said. First of all, there is the drafting of an arbitration clause, which is a classical solution. Well, here, whenever it comes to drafting the arbitration clause, it's important to say that the first issue to be resolved is to know whether a public entity, the state, the Lebanese state, can eventually resort to private ways of settling disputes, i.e. arbitration. And here there has been, a long evolution, and this issue has been settled by a law in 2002, and that recognizes for the Lebanese state the possibility and the arbitrability of these disputes that no longer raise any difficult problem. However, there has been a pre-requirement that has been implemented that is it's a prerequisite, that is a prior authorization that has been imposed from the Council of Ministers. And this is a condition of efficiency of any arbitration clause. Generally, it's not that complicated to get these kinds of authorization. But however, these kinds of authorizations can be in conflict with international practices. Because it's a well-settled idea that a state cannot rely on its own restrictions in order to jeopardize its own commitments, and therefore, refuse to enforce its commitments that it has willingly adhered to. But I won't stress on this matter. That is not our problem, but it's important to point out this issue because it's a key factor. Whenever the drafting of a clause, of an arbitration clause is involved, well, there is many options here. And the most important is to select the appropriate option. Generally, in investment disputes and oil and gas disputes, the first reflex is to insert an ICSID clause. ICSID is an institution, it's an international center for settlement of investment disputes that has been established by the Washington Convention. And Lebanon has adhered to the Washington Convention, and this convention has been elaborated under the auspices of the World Bank. This is, of course, the most important institution worldwide in order to settle investment disputes. And, of course, referring to ICSID, to the institution, to ICSID, is, of course, a highly appreciated way of settling disputes. And the Lebanese state has already been party to two cases before the ICSID. One of them has been sold out by the gain of the Lebanese state, and the second one is still pending, which gives us an idea that it's no longer a strange method for the Lebanese state. But the ICSID is not the only way to settle investment disputes and oil and gas dispute. Well, the ICC, when they revised, they modified their latest rules in 2012, and I was member of the commission of the revision of the ICC rules. We worked very hard in order to encompass investment disputes, and of course, among them, oil and gas disputes and state disputes. So ICC is of course, one of the most important institutions worldwide in order to settle these kinds of disputes, because, the investor will be reluctant to go before a local institution, of course. And the Lebanese state also has not been strange to, gas to ICC. There has been ICC cases involving Lebanese state and mainly focused on gas, because there was a contract that was concluded back in 1999. And in this contract, there was an American party that was charged, that was commissioned in order to fill in the sea before the Beirut seashore. And the contract was, of course, signed with a Lebanese public entity. It was not listed, but it was a public entity. And while executing the digging, work? Well, they found gas, emanations of gas, which gave rise to some additional costs, and the American party refused to support these costs, the extra costs. So there has been a dispute between the Lebanese party and the American party, and they resorted to arbitration, and this case was sold out here again by the gain of the Lebanese state, because the arbitral tribunal considered that well, the American party should have foreseen and should have studied the underground before signing the contract, and so this well falls within its responsibility in the contract. So this gives us an idea that gas has already been subject to disputes, even indirectly, yes, of course, but it has been already a matter of disputes before institutions. And allow me to add that it's not only ICC, it's not only ICSID. You can resort to ad hoc arbitration. Ad hoc arbitration is according to ancestral rules. Well, the Lebanese state very often refers to these kinds of rules. But then again, it's not exclusive. So the most important thing to stress upon is that it's necessary that the selection of the option of the way of settling disputes should be tailored upon the specs of each case. So this is a very major issue. And, of course, resorting to the appropriate drafters, appropriate persons, qualified persons is here, again, some necessity. And I can't sufficiently enough stress on the necessity of resorting to qualified persons in order when drafting these contracts. Well, the other way of settling disputes relating to oil and gas and generally investment disputes is by leaving the matter to international conventions and treaties, and most particularly to bilateral international treaties. Well, one of the peculiarities of investment contracts is also being subject to resolution by arbitration on the basis of treaties, even though parties have not subscribed, have not inserted an arbitration clause. And that by leaving the matter to international instruments. The Lebanese state has signed not less than 53 bilateral investment treaties, and many of them refer to arbitration. Some clauses, some provisions of these bilateral treaties are very common, do not raise any significant problems. For example, the Franco-Lebanese BIT that refers that in case an amicable settlement has not been reached, well, the case should be referred to ICSID, which is a very classical and common clause. But there are some more complicated provisions and clauses in BIT, like the Lebanese-Canadian BIT that provides that failing an amicable resolution within a certain period of time, well, parties should resort to ad hoc arbitration according to the ancestral, or provided that the investor withdraws from any procedure led before any local court. But the enforcement of BITs could raise many problems, of course, and therefore, for example, the umbrella clause, the most favored nation clause, etc. So there are many issues, and namely the conflict that could rise from the conflicting provisions between agreements and BIT. So I won't, of course, the time will not allow me to dig deeper in these kinds of issues, but here again, it's important to stress on the fact that, it's important to resort to a qualified person, not only for drafting the BITs, but also in order to resolve disputes by arbitration and draft arbitration clause, because this is a key factor for the efficiency, the whole efficiency of course, the petroleum and gas contracts. I thank you for your attention, and I hope this forum will be the opportunity for us to well, to make ourselves heard in order to, well, of course, to stress on the importance of qualification in this matter, and of course on the importance of dispute resolution in this branch of law. And I wish you a pleasant afternoon. Thank you.